Good afternoon, everyone, and thank you all for joining us for today's presentation. My name is Marissa, an attorney with Legal Aid of North Carolina's Helpline. Today, we have Matt Sessions presenting for us. If you are unfamiliar with the format of this event, first, Matt is going to review a PowerPoint presentation. At the end of the presentation, we will have a question and answer session. If at any point during the presentation you have questions, you can put them in the Q&A box on Zoom or the comments section on Facebook. We'll review all questions put in the chat boxes during the Q&A session at the end. Please remember that this is a public forum and legal aid is not representing you at this time. Matt will go over this in more detail, but please remember to keep your questions as general as possible as we cannot provide any legal advice specific to your individual situation. The session will end when there are no more questions, and regardless of where we are, we will have a hard stop at 4:30 p.m. With all that being said, I'm going to pass it over to Matt to get us started.
Good afternoon, everybody. Again, my name is Matt Sessions, as already stated. I'm an attorney with Legal Aid of North Carolina Senior Law Project, and we're going to be speaking about wills and advanced directives. The title of the presentation is a talk on end-of-life documents. And we can go to the next slide. So what I'm going to be talking about today is what these documents can do, the common types of those documents, and the signing requirements. We can go to the next. Yep. As previously stated, I can only give general information. I cannot give specific legal advice to your situation. I will be discussing North Carolina law only. So if you've got a question about, if you were living in another state at a time or something along those lines, I can't answer that. Okay. We can go to the next slide. Legal Aid of North Carolina is a statewide nonprofit law firm that provides free legal services and civil matters to low-income people in order to ensure equal access to justice and to remove legal barriers to economic opportunity. So some of the common cases that we handle in general are obtaining domestic violence protective orders to protect survivors of family violence. We help tenants fight evictions, fighting illegal terminations of public benefits such as food stamps or Medicaid, assisting homeowners in foreclosure, and stopping illegal debt collection. So here are our big four for our estate planning documents. These are the most common that you'll see. There are others, but these are the four that we assist with at Legal Aid of North Carolina. We have your will, a financial power of attorney, otherwise known as a POA, a healthcare power of attorney, and then the last document is a living will. So why should you have these documents? These documents can be helpful to you and your loved ones if you become sick or incapacitated. They can help make sure that things happen the way you want them at the end of your life and after you pass. They can be especially important if your biological relatives are not the people you want assisting you in an emergency or inheriting your property after your passing. So what is a will? A will is a legal document that sets out who inherits your assets after you pass away and who is to manage the property until it's passed to your heirs. It says who gets your stuff, so your real estate, which are your home and land, cars, money, etc., after you pass away. It names who will handle the paperwork to make sure those people indeed get the stuff, which is called an executor. So when does a will take effect? A will has no effect and no meaning until the day that you pass away. You can change your will every day of your life if you wanted to, as long as you're still mentally competent. The only will that would be followed is the last one you executed before you pass away. It does not transfer any ownership interest while you're still living. So what happens if you choose not to get a will and you die without a will? If you die without a will, your property does not go to the state. Your assets pass by North Carolina law, which is called the laws of intestacy. Basically, your assets will go to your closest family members, but only through legally recognized relationships. Exactly who gets your property depends on a lot of factors like the makeup of your family and how your assets are titled. So, wills that involve minor children or disabled adults, in your will, you can nominate someone to become the guardian of your minor children or of a disabled adult over whom you have guardianship. This is not binding on any court, but would probably be very persuasive to a judge. An alternative is a standby guardianship. This sets someone up in advance to be a guardian over a minor child or disabled adult. This can be done through a petition in front of the clerk. It cannot be done in a will, and it requires that the parents and guardians have a fatal or progressive chronic illness. So we hear a lot about handwritten wills in mainstream media, and those are also called holographic wills. This is an option if you want to get if you cannot get an attorney to prepare a will for you right away. This should be a temporary stopgap solution. You should go to an attorney to have a will prepared as soon as it is feasible to do so. So the requirements for a valid handwritten will, it has to be written entirely in your handwriting and it has to be signed by you, found in a proper place like a safe deposit box or with other important papers or with someone for safekeeping. And after your passing, 3 witnesses have to testify as to the handwriting and 1 witness to testify as to the will being found with important papers. So if you're going to do a handwritten will or a holographic will, you want to keep it simple. Distribute property clearly with no conditions. Identify property clearly in a way even a stranger could understand it. 136 Oak Street, for example, not the old home place or the mountain house. Remember that a will is a financial transaction. Save statements like how much you love your family or other means of communication. What is a power of attorney? When people just use the term power of attorney, usually they mean the one for financial affairs. A financial power of attorney is a document that names someone to help you out in financial and personal business matters. The person who helps you out is called your agent, although people often use the term POA for the actual person. Examples of things your agent could do for you. They can write checks from your bank account, transfer money from your savings account to your checking account, call your car insurance company to cancel your car insurance, call the county tax office to ask if your real estate taxes are up to date. When does a POA take effect? So you can choose when your agent will be able to help you. Right away is one option, and this does not mean that you cannot act for yourself, but the document takes effect immediately. Or only upon some future event, such as if you become incapacitated and can no longer handle your financial affairs yourself. So, can you put limits on your agent that you name in your financial power of attorney? Even though your agent is given access to your finances, the agent must use your money in a way that benefits you and you only. For example, your agent may have the authority to write checks from your account, but the agent should not write a check to pay her own cell phone bill. Warning: the financial POA creates the potential for financial abuse and exploitation. It gives someone access to your money. Agents are not supposed to use this access to benefit themselves, but this does not mean it never happens. You want to be very, very careful who you pick to be your agent under a power of attorney. So, what's the difference between a power of attorney and a guardianship? A power of attorney by itself does not take away any of your own decision-making power. You make the choice who you want to serve as your POA. If you become incompetent, on the other hand, the court will decide who will have the decision-making power and what specific powers they will have by appointing a guardian. This is a big question that I get a lot. How do I get a POA over my parent? Answer: you can't. Only the principal, person who's being helped, can execute a power of attorney. An agent or the helper or other family member cannot execute a POA on behalf of someone else. If the principal is unwilling or unable, like being incompetent, unconscious, etc., to sign a power of attorney, there is no way to get one. The only option at that point would be seek guardianship, which requires a court order declaring incompetency. What is a healthcare power of attorney? A healthcare power of attorney document names someone to make your medical and healthcare decisions if you are no longer able to make those decisions yourself. For example, if you have a car accident or are unconscious, your healthcare agent could decide if you want to have surgery right away or wait. What kinds of things can your healthcare agent do? So here are some examples. Request and review information about your medical condition and consent to its disclosure. They can hire and fire your healthcare providers, consent to you being authorized or admitted and discharged from healthcare facilities or mental health care facilities, consent to and authorize administration of medications, surgery, x-rays, anesthesia, etc., authorize the withholding or withdrawal of life-prolonging measures, authorize an autopsy or directing the disposition of your remains. Basically, any medical decision you can make for yourself unless you put a limit on it. What is the difference between a financial power of attorney and a healthcare power of attorney? The financial power of attorney deals with financial matters, and the healthcare power of attorney deals with healthcare and medical matters. Having only one document does not give your agent the authority in the other arena. For example, your agent under the healthcare power of attorney could not close out your bank account for you. So when does a healthcare power of attorney take effect? Unlike the financial power of attorney, the healthcare power of attorney only takes effect if and when you are no longer able to make medical decisions yourself. As long as you can make and communicate your own medical decisions, your doctor should always go to you and only you. What is a living will? A living will is a document that tells your doctors that if you're getting towards the end of your life, you do not want certain extraordinary life prolonging measures. Also, this is called an advance directive for a natural death. What is the difference between a healthcare power of attorney and a living will? A healthcare power of attorney names someone else to make your medical decisions if you can't make them for yourself. A living will expresses your own desires and wishes for your end of life care. There's often some overlap between these two documents. For example, you can put in your living will that you want your healthcare power of attorney to have authority to override the wishes in your document. A DNR or do not resuscitate order is a medical order and it must come from a doctor. A living will is a legal document that you execute yourself, probably with the help of a lawyer. A lawyer cannot give you a DNR order, only a doctor can do that. When does a living will take effect? You can choose the specific triggers in your own living will document, but here are some of the common ways. Incurable or irreversible condition that will result in your death within a relatively short period of time, or you're unconscious and to a high degree of medical certainty will never regain consciousness, or you suffer from advanced dementia or any other condition resulting in the substantial loss of cognitive ability, and that loss to a high degree of medical certainty is not reversible. You can choose any or all of the three triggers. Requirements for the valid execution of these documents. In general, there's three requirements. They have to be signed by the maker, which is you, signed by two witnesses who have to be disinterested, and it must be acknowledged by a notary. The one exception to this in these documents is the power of attorney. The financial power of attorney does not require two witnesses. The financial power of attorney only needs to be signed by the principal and notarized. Here on this page, there's some additional resources listed. Okay, and we're at questions.
Perfect. And so if you have a question, you cannot unmute in this form. If you have a question, you either need to put it in the Q&A box on Zoom or in the comment section on Facebook. First question that I'm seeing here, someone is asking, say someone suffers from like dyslexia or something like that. Do they need it? What kind of power of attorney would they need if they wanted some assistance with their health care and financial needs? Is there a specific kind of power of attorney someone needs when they have dyslexia? I think that's what the question is asking.
I'm
I
not
don't know if you
familiar
can
with
see
it,
the
but
question.
I
You might be able
can.
to pull. Yeah.
I saw it in the Q&A box. Um, I'm
Yeah.
not I'm not aware of a specific type of power of attorney as long as they're competent. And they have. I would think if they. I don't know. That's a good question. I would think as long as they're competent, they could complete the forms. If their attorney and them, go over them together.
Oh, I
If they
think
can't.
they're asking how does someone do these forms if they can't read or write or something like that. Okay, that's a
Okay,
good
so
question.
um, part of that's gonna to go to notarization, but as long as they can make their mark and they're competent and understand what they're signing, they can proceed with the documents. Uh, because in many of the spots, you're only initialing the document or signing your signature on it.
There's something to be a will or a power of attorney or a healthcare power of attorney. Is specific language needed for these types of documents?
Was that in terms of the dyslexia question or
I'm not sure.
okay?
It's a different person, so I'm not sure if there's a specific document. So maybe just speak in general to all the documents about specific
Uh,
language, maybe.
uh, yeah, okay. So yeah, there is specific language in some of the documents that needs to be there. But you would have to go over that with the attorney when you go to execute those documents. I do see a question. How much does it cost to have a lawyer put together a will? Obviously, they range. So I'm not going to go into that. It depends on who you decide to go with and all of those things. Legal aid does provide services at no cost. Obviously, you have to qualify for those services. And I think on the previous slide, it had our helpline number where you can call to look into that.
I am putting a link in the chat now to the North Carolina Law Referral Services, where you can also find information about attorneys in North Carolina. Let's see. Man.
Okay, I see a question after that one. Can one adult child of an aging parent be both a financial power of attorney and a healthcare power of attorney? The answer to that is yes.
I'm gonna give it just a second here to see if any other questions do come in. You see that question, Matt?
Sorry.
I can take the eligibility for legal aid question when you're done with that
Okay. Okay.
one.
Hi, thank you for this information. If someone wants to name a guardian to take their place upon their death, is there a special place in a will to nominate? Uh, I guess the question's, you can name I'm assuming this is with a disabled adult or with a child that you're already a guardian or parent over. You can name someone that you would like the court to put in as guardian, and nominate somebody on your behalf.
Next question is about how do you qualify for to qualify for legal aid? You have to both be income and asset eligible. There are some instances where some really, really limited instances where income and asset eligibility is not a part of the situation. But as far as for most of our wills work that we do here at Legal Aid, you likely have to be income and asset eligible. Now that is dependent on the household, who's working in the household size, and things of that nature. So I can't speak to specifics. But the best way to find out is to either use that phone number and apply when our phone lines are open, or to apply online to see if you can qualify for services. Checking Facebook really quickly. Okay. Well, as I am not seeing, oh, how do you feel about online builders for these kinds of documents?
Yeah, I don't, I see the freewheel.com. I have no experience with it. Yeah, the only thing I'll say in regards to that is every state has different eligibility things for what makes it, like we talked about already in the presentation, about what makes a will valid or these documents valid in that state. When you do a general online thing, some of those requirements may not be met. If you're going to go that route, you would really need to do your research and make sure that it's correct. So overall, for a broad answer, I would say I don't have specific, like I said, I don't have specific knowledge about this website, but in general, I would say to not go that route. And if you're thinking about something like that, I would even push more towards doing a handwritten holographic will, which we went over in the presentation, than some of the options that are online because they're not specific to North Carolina a lot of the times.
And then for the person asking, what does it mean to be income and asset eligible? The person who is being helped, that is the person who needs to be income and asset eligible. The person with the family, that household. Um, I think that's the only way I can answer that. Ooh, that's a good question.
And I'm reading it now. I honestly do not know. I'll have to research that and see if you can provide your information. I can try to reach back out.
Uh,
That was it. I was speaking about the healthcare with no healthcare power of attorney in
yeah,
place. Yeah.
I don't know if we can really respond to the next one because it's not really the can't afford an attorney thoughts about writing a will. I mean, you can go over that. That was discussed in the presentation, and so it's not really a question I think we can answer because it's not really a question. Okay, so I'm gonna dismiss that one. We're just gonna dismiss them. Okay, all right. And see if anything else pops up while I'm talking. Um, And so, since I am not seeing any more questions, I'm going to go ahead and say thank you all for joining us, with a special thank you to Matt for presenting and for answering all of those questions. If you would like to review anything that was discussed, um, there's a new question in the chat. I will let you
Okay.
determine whether or not you can respond to that.
The best option if you look at the available resources like the North Carolina Lawyers Referral Service, also reaching out to your legal aid helpline number or the online option. But again, I spoke about it in the presentation. If you can't afford a will or those options don't work out that were previously mentioned, in my opinion, the best option for you to do is to do a holographic will. Which is what we spoke about earlier, where it's entirely in your handwriting. And there's some other requirements that were in the presentation, but that would be the best option.
Hold on. Yeah, hold on. There it is. Okay. So I'll just leave that up as to go ahead and say thank you to all of you for joining. Thank you to Matt for presenting. If you would like to review anything that was discussed today, we have posted a recording of today's event to our Facebook page. It will be immediately available following this event for about a week, and it can be accessed on Facebook with or without a Facebook account. If you want to review it later on, you will need to go to YouTube, our YouTube page. It will be at www.youtube.com/legalaidnc. If you would like to register for one of our other Listen and Learn programs, such as Medicaid, SNAP, Social Security Disability, Child Custody, you can do so on our website at www.legalaidnc.org/clinics. Thank you all so much, and I hope everyone has a great rest of their day.
Thank y'all.